Well, good morning. Today, the Office of the Attorney General filed a motion for leave to file a petition for writ of mandamus with the Illinois Supreme Court in conjunction with the special prosecutor from Kane County State's Attorney, Joe McMahon, in the matter of the people of the state of Illinois versus Jason Van Dyke. This is the first step in asking the court to declare that the trial court improperly sentenced Jason Van Dyke for the murder and aggravated battery of Laquan McDonald and to order a new sentencing hearing. Challenging a sentence through a mandamus action, a request that the court compel a public official to perform a mandatory duty, is not an everyday occurrence, but neither is it uncommon. Because the state cannot appeal in a criminal case, this avenue is our only recourse against a statutorily unauthorized sentence. As Attorney General, with the constitutional and legal duty to represent the people of the state of Illinois before the state Supreme Court, I am convinced that it is my responsibility to file this petition and to work in conjunction with the special prosecutor, State's Attorney Joe McMahon, to challenge this sentence. I have arrived at this conclusion after consulting extensively with the office of Mr. McMahon, who served as a special prosecutor at trial, and carefully reviewing both the record in this case and the laws of this state. Specifically, this petition asks the Illinois Supreme Court to decide whether or not the trial court judge acted improperly by determining that Van Dyke's sentence based on his second-degree murder conviction rather than his convictions on 16 counts of aggravated battery with a firearm. We are also asking the court to decide whether the judge was incorrect when he stated during the sentencing that 16 aggravated battery counts merge into a single act for the purposes of sentencing, rather than sentencing Van Dyke on each one of the 16 counts. Our petition argues that if the Supreme Court orders a new sentencing hearing, it should also order the trial judge to follow precedent by imposing sentence on all 16 counts, and then determine whether one or more sentences must be consecutive. The filing today is a motion for the Supreme Court to allow us to move forward with filing the petition. The next step is for the court to rule on that motion. Within 7 days or another deadline imposed by the court, Van Dyke may choose to file an objection to our petition. Throughout this process, my office will collaborate closely with the Office of the Special Prosecutor. While there are many who have opined on the appropriateness of the length of sentence in this matter, I recognize that a trial judge's discretion in sentencing is to be given great deference. However, it is in the interest of justice that we do all within our power to make sure that such exercise of discretion be applied consistent with the mandates of law, no matter who the defendant and no matter who the victim in a particular case. It is an honor to work with Special Prosecutor and Kane County State's Attorney Joe McMahon. He courageously stepped up to handle this case when others would not. So I will now turn over the podium to Joe McMahon.
Thank you, Attorney General Raoul. As he indicated this morning, we did file a joint petition for writ of mandamus to the Illinois Supreme Court, asking the Illinois Supreme Court to review the sentence imposed by Judge Gahn several months ago now. The focus of our petition is for clarification on the sentence that Judge Gahn imposed, and asking the Supreme Court to order Judge Gahn to impose a sentence not just on the second-degree murder count, but on the aggravated battery with firearm counts as well. I look forward to working with the Attorney General through this process. I welcome his support. I'm grateful for the words that he just shared of me and my team, and we look forward to working with him and this office through this process in front of the Illinois Supreme Court. Thank you.
Questions?
Yeah, Mr. Attorney General, this seems, perhaps some outside of this room and who weren't in court, this might seem like an extreme measure. There was due process, there was a trial, there was a jury, there was a sentencing hearing. Do you consider this extreme?
No, I consider this, as said in my introductory remarks, an action that is brought about. While it's not an everyday action, we have engaged in this before. We have worked together with, on one matter last year with the Kane County Prosecutor's Office, and on a couple of other matters with other prosecutors' offices. What is critical in this is, again, this is not a question about the judge's discretion in the length of sentence. This is a question of whether the law was followed and whether sentence was rendered on the appropriate count, appropriate charges.
Do you think the law was followed?
Well, obviously, by filing this petition, I do not.
Does this come with any risk?
Risk of what?
Reopening the process.
I don't look at this as reopening a process. There's a case that came to conclusion at the trial level. The defendant, in every case, I began my career as a criminal appeals prosecutor. I handle many appeals. Cases don't necessarily come to an end at the end of a trial. They're often brought up to the appellate court and sometimes to the state Supreme Court.
I'm just wondering, are there some unintended consequences that might come with this? Perhaps you'd like to answer this too.
So there's always, anytime there's a criminal conviction, there is likely going to be an appeal. In this particular case, we were notified late last week that the defense has filed a notice of appeal that has been filed with the First District Appellate Court. I have not seen the actual appeal, but we were notified. So is there risk? There's always some element of risk. Yes, there is. Anytime a case goes up on appeal, whether it's to the appellate court, whether it's us bringing a petition to the Illinois Supreme Court asking them to review a sentence. But I think what's important to remember in this case is that for so many different reasons, there are really important issues that came forward, not just in the trial of this case, but during the sentencing of this case. Those issues would have come out whether it was during the appellate process, whether it was during the post-conviction process, which could have come whether or not an appeal was filed immediately or not. But ultimately, it was to make sure that the law was followed in all aspects. And this step by the Attorney General and I this morning is our effort to make sure that the law is applied equally to this case like it has been to every other case, and that this defendant is, the law is applied to this defendant as they do to all defendants.
So that made you say on the day of the sentencing, essentially, that you were satisfied with the sentence. What changed?
Well, I am satisfied with the sentence, but as we have had an opportunity to step back and kind of evaluate both the law and how the sentence was imposed, we have the benefit of some time and counsel in working with the Attorney General's office and him. And I think the bigger message in this case is to make sure that the sentence that is imposed is a sentence that is lawful under both the legislative intent and the law as set down by the Illinois Supreme Court. That's why we filed the writ this morning.
Can you elaborate on, I guess, some of the background or the prior court decisions that you believe supports your decision to file a writ of mandamus? Has this ever been done before? The state filing a writ of mandamus to change a defendant's sentencing after the trial?
Yes, it has been done, and
Yeah, it hasn't been done before. There are 3 such writs that we identified from last year. I don't have the cases before me, but I think part of your question asked with regards to the appropriateness of the review of the legality of the sentence.
I was just wondering, has the state ever filed writs of mandamus before challenging?
Yes.
And what were did the Supreme Court?
We'll get
accept?
that too. It varied in different cases. You know, there are some cases. There have been cases where the Supreme Court chose not to act on the petition, and there are cases where they acted otherwise.
What's the timetable on this? How soon do you go back to the Supreme Court, and how soon could any kind of review take place?
Well, there's no strict timetable on the Supreme Court. You know, in my experience with courts of review, it widely varies. As indicated, either in 7 days or in a time that the court deems appropriate, the defendant can file an objection to our petition.
Are you alleging any improper action apart from his ruling on the part of the judge? Did he do something illegal in your opinion?
I'm not casting aspersions on the judge. The question is whether the sentence was consistent with the laws of the state of Illinois, and it is our belief that the sentence was not.
Mr. McMahon, after the sentencing, you said you were in touch with Laquan McDonald's family.
Mhm.
I'm wondering if that conversation has continued, what role they played in this decision, and if they're supportive of it.
I have continued to speak with them. I spoke with the Reverend Hunter several times, 3 or 4 times in the last couple of weeks. He is supportive of it. I have indicated a number of times that this whole process has taken an incredible toll on Laquan's mother, Tina Hunter. I think she would like the process to be over. Whatever the outcome, she would like the process to be over. I think to the extent that she can move forward, I think the end of the process will help her move forward, understanding that a mother never really is able to move forward from the loss of a child. So I believe that the family is supportive. I've spoken with Reverend Hunter a number of times. You know, I don't speak for him, but my belief is he's supportive of this move.
Is this your last opportunity to address this verdict?
So the only, it's a very narrow circumstance that the state can actually appeal a sentence. We cannot appeal a sentence, but we can petition the Illinois Supreme Court, which is what we've done this morning. And this is the only way for us to challenge the legality of a sentence. We cannot wait for a defendant to raise this issue on appeal and then address it in our response to the appeal that the defendant raises. So this was kind of our one and only opportunity to challenge the legality of the sentence. There's an issue on timing. We couldn't wait and watch the outcome of the appeal to maybe eliminate some of these other risks. That really wasn't a possibility. One of the defenses to a petition for a writ of mandamus is the timeliness with which we act or fail to act. So we took the time that we needed, but we acted as expeditiously as we could. This is an issue that my office and the Attorney General's office have been working on very closely for the last couple of weeks.
Mr. Attorney General, if this law was improperly applied by the judge in this case, is this an indication that there are larger, more systemic problems with defendants being sentenced throughout Illinois without the spotlight that this case has enjoyed from the very beginning?
Well, I haven't been party to any such cases with regards to the application of the doctrine that leads us to question the sentence in this case. So I can't speak to the extent to which this has happened in any other
Will you be launching
case.
a review of similar cases? Because if the judge got the law wrong in this case, isn't it possible that other judges in other cases have gotten the law wrong too, and there are people who have been either sentenced to prison for too long or for too short?
Listen, if anything is brought to my attention that is actionable, that is improper, we will weigh our options at that time. I'm not. I'll leave it at that.
Anticipating that some of the response to some reactions going to say that this is motivated by politics, what do you say to that?
Oh, I would say that is nonsense. We have worked together with the special prosecutor, who again courageously stepped forth at the outset of this case. This is a question of law, and it's in the interest of justice that the law be followed, no matter who the defendant and no matter who the victim is in a particular case. And that is not a political question. That is a question of law.
But I gather you think this sentence is too light.
This is not a question of whether I believe, and I'm not going to opine on my opinion on the length of the sentence. What I will opine on is whether or not the law should be followed, and I believe that the law should be followed.
Thank you.
Thank you.